Hello everyone and welcome to episode 6 of Jones White's There Are Some Things Certain in Life. This series is all about making daunting later life planning and other legal matters a little bit easier to understand, bringing our decades of legal and life experience to help dispel the myths and provide some hints and tips to make getting your legal affairs in order a little bit easier. I'm Ross, as always, a dual qualified Scottish and English and Welsh solicitor with many years experience in all things later life planning, including wills, powers of attorney, trusts and inheritance tax. Now my usual colleague Stephanie, she's off on holiday today, getting some sunshine, having a well-earned break. So I'm delighted to be joined by my colleague Steven Bain from our family law team. Steve is one of Scotland's leading family law solicitors with extensive experience in divorce and separation, and in particular, cases involving complex financial situations. Welcome, Steve.
Thanks, it's great to be here.
So today we're going to tackle something which crosses both of our areas, ultimately family trusts and divorce, and specifically how trust planning can protect inherited wealth both for your children and for yourselves.
Yeah, I mean, it's a topic that comes up constantly in our line of work when I'm speaking to clients. People will put an enormous amount of effort into building up their assets and their inherited wealth over their lives. And it can be absolutely devastating for them to suddenly watch that be put at risk, depending on what their situation is. And often that didn't need to be the case in the first place.
And from my side, these are conversations I'm having with clients every single day. Ultimately with parents, with grandparents, worried about what will happen in the event that their child's relationship breaks down in future. They've worked hard, they've saved, they've tried to instill that work ethic in their children and hope that that translates into the relationships that they ultimately have. But they want to apply some meaning to the wealth that they've created and ultimately make sure that it's safeguarded for the future. Just last week, speaking to clients, and that was their concern. Ultimately, we have an estate well over £1 million. We're leaving it all to our son. He has a new partner. She seems perfectly nice, but we don't know her well enough to be giving her half of our estate.
Of course. So
it's ultimately how can we safeguard against that in future. So Steve, before we jump into solutions to this sort of concern, help us paint the picture. What do you see in your line of work about kind of what happens when inherited wealth meets divorce?
It's much more common than I think you'd realise. Someone inherits money, maybe from a parent, usually from a parent. Quite often that would be the family home, for example. And at the time of divorce, that asset's sitting there in that person's sole name, or it's potentially been mixed in with the matrimonial pot. That's a term the courts use to define the assets that need to be looked at in that divorce setting. The other spouse's lawyer is going to start looking at that with a fine-tooth comb and go through and examine exactly what that wealth looks like and try and get as much of it into that melting pot as possible. And suddenly an inheritance that was never meant to benefit the spouse, as you said in your example, it ends up being divided or it ends up being considered as part of that melting pot.
And we'll talk today about kind of the timing of making sure that you've got planning in place to make sure it's done properly. But you must have clients all the time asking you, listen, I've got this and I'd rather they not get a bit of it. And it must be really difficult for you dealing with those situations.
It is. I mean, absolutely. The emotional dimension, I suppose, is probably the worst part for people. When they're coming into us, it's not just money they're talking about, but the house, for example, that we talked about, that's got a huge emotional attachment for these people. It's not just looking at figures. It's something they know that their family have spent decades working really hard for. And people feel really strongly that that needs to stay in the family.
Yeah. And it must become quite acrimonious.
Oh, all the time, all the time. It's one of the, I suppose, the hardest things we have to deal with or walk on eggshells as much as we can in those scenarios. And I think we'll come on later on to discuss that. But certainly when we're looking at prenup arrangements, then that becomes very apparent at that point as well.
And it's not just big estates, as you said, it's about the emotional impact. It can be modest inheritances too. So a small flat, some money. But ultimately in someone's eyes, that's something that their parent has worked for. And they want to make sure that it stays within the family and doesn't go out with the family. And that's exactly why good trust planning, or what it's designed to do ultimately. So I think we'll look at this from two angles. There's the parent or the grandparent trying to safeguard the estate or the inheritance of the children in future. And then there is the person themselves potentially entering into a marriage and what trust planning can do for them in terms of safeguarding the estate in future. If we start with the sort of parent-grandparent perspective, I'll often sit down with clients in their 50s or 60s, and as we said earlier, we wanted to go to our children, but we're worried about something going wrong in their life. Now, that might be the child is doing something that they shouldn't be doing. It might be that the child has debt or creditors. But more often than not, it's about what will happen if our child goes through a divorce or separation in future. And that usually is because they haven't met somebody yet and they don't know what that future is going to look like.
That trust takes time to build up.
Exactly. Or it's someone who's been in the family for a relatively short period of time. And for those clients, that's generally where I'll talk to them about making sure that they have a will in place, but it's the right will with trust provisions within it to make sure that the estate is held for the benefit of their children or their grandchildren, but not in their names outright. And the reason for that is if we have a simple will, as we've touched on in previous episodes, and that passes down to the children, then that forms part of their estate. So if they then take that and they muddy the waters in terms of their relationship, and they buy a lovely big house and live happily ever after for a short period of time until they live not so happily ever after, then that inheritance is part of the claim potentially.
Absolutely. And I always talk to my clients about it's our job to catastrophize. So we need to look at the worst case scenario that they might not want to look at. But what you've said is exactly right. I mean, when the courts are looking at these things, you've used the phrase melting pot, and that's quite a good term, although matrimonial pot is what we would talk about from a legal sense.
Yeah.
And that is all these assets that have been acquired during the course of a relationship. But inheritance is one of these unusual ones where, on the face of it, inheritance is excluded from the matrimonial pot until, and this is the kicker, until such time as it changes in nature. So you talked about an example of, we've got this inheritance, we'll pay off the mortgage, for example, or we'll buy a lovely new house. And as soon as that happens, that money's then up for grabs. And that's the difficulty. That's where we have to look at proper in-depth planning. And I mean, you talked about having up-to-date wills as being a key part of all this, and we will advise every client that comes through our door that that is something they've got to be looking at as soon as they know either separation is on the cards or has already happened. Make sure that will has been updated to reflect what your wishes actually are.
Yeah, because we've both seen situations where, unfortunately, in the midst of a divorce or separation, somebody passes away and the will doesn't reflect what stage of life they're at that point.
Absolutely. And if we've not been able to assist that person in the interim, whether it be a minute of agreement at that stage, then there's going to be trouble.
Now, the law in Scotland does give some protection, as you said, but it's not absolute. And in England and Wales, the discretion is even wider. So what's the alternative? As we've said, instead of leaving an inheritance outright, a parent can leave it within the discretionary trust. The child benefits. They can receive an income, the trustees can manage assets on their behalf, but it's not theirs. It belongs to the trust.
Yeah, absolutely. And from a divorce perspective, then that changes things materially. If the asset's held in trust, then the child has never actually owned that asset, and all the courts are focusing on as far as division of those assets are concerned is assets that have actually been owned by that child. The official terminology is through the joint endeavours of the parties during the course of the marriage, but if they've never actually owned that asset, it's not applicable in that sense.
And I think it's important to stress that if it's done properly, the child doesn't necessarily lose out. They will be a beneficiary of the trust that will be managed on their behalf. So a well-drafted trust gives them the flexibility to support the beneficiary, but not necessarily restrict how they benefit in future.
Yeah, absolutely. Although I'd say, and you might well correct me here, but trusts aren't completely bulletproof. And courts can look behind the circumstances of those. And that's where, both from a lifetime planning perspective, but also from a divorce perspective, it's important that they're set up for the right reasons.
Absolutely. As I always say, when we're looking at any type of estate planning, it's about the right planning at the right time. A trust, as you say, set up just before something happens to avoid that thing. The courts potentially will see right through it, as you say. But a well-established family trust put in place for sound estate planning reasons at the right time for the right reasons ultimately can offer the protection that our clients are looking for. And that's why everyone has to have independent advice unique to their circumstances. There isn't one size fits all, one silver bullet to solve these problems. It's got to be the right thing for you and your family. So I think if we flip the perspective and we start looking at clients who themselves are worried about the assets that they've accumulated potentially being lost in a divorce situation in future, that's a little bit more difficult. When you speak to clients and they're coming to you, at the other end, when they're setting out on a new relationship, a new marriage, and they're concerned about what would happen if things go wrong in future, what's the first piece of advice you give them?
Yeah, I mean, the first thing we talk about is a prenup or prenuptial agreement, to give it its full terms. It's an emotive word for people. And as soon as we start talking about prenups, then there seems to be some kind of automatic assumption that we're assuming that relationship is going to fail. But if you take that and flip it on its head, then the parties aren't entering into that marriage for financial gain in the first place. Therefore, there shouldn't be any difficulty with them entering into a prenuptial agreement. They'll be having open conversations about these things anyway. And certainly from our perspective is making sure that the marriage is setting out on that right financial footing, that everyone knows exactly where they stand, and all it's going to do is prevent further stress further down the line.
And are they enforceable in Scotland, prenuptial agreements?
If a prenuptial agreement isn't worded correctly, so if it's a poor prenuptial agreement, then there's definitely options there to challenge it. Don't get me wrong, if you're getting a good prenuptial agreement done, then they are strong. They're very strong, and more times than not, 99 times out of 100, they'll achieve their purpose. But certainly if it was a poorly worded prenuptial agreement with loopholes in it, if it's not drafted correctly, it's always going to be open for challenge through the courts.
And I think it's important to stress that both parties entering into that should be having their own independent legal advice before they sign any of those documents.
Absolutely, and that's always part of the conversation that we're having. Quite often we'll get a client that will turn up to us and say, I've been completely honest with my wife, my husband, whatever that happens to be. They're completely on board with this, and that's all grand. But if we were to push ahead and draft that agreement without acknowledging the fact that the other side had to get that representation, that leaves it open for challenge in itself. That big bad lawyer bullied me into signing this agreement. We're trying to avoid that. We make that very clear to our clients that that's fine. They may be in agreement, but we'll still be advising them to get their own independent legal advice.
Absolutely. You and I actually had a case a few years ago, bit of a kind of strange story. The gentleman actually had set up a trust with his first wife. She'd passed away. He was entering into a new marriage, and they were looking for a prenuptial agreement, and that was a situation where they were very strongly of the opinion, no, we know what we want, just write it down and we'll sign it. And you quite rightly were saying, aye, very good, mate, because when that goes wrong, you'll come shouting at me.
Exactly. And normally when folk are looking for a prenup, it's because they've got substantial assets to protect in the first place, whether that's inherited wealth or whether that's a business, whatever that happens to look like. It's normally done because there's enough assets there to argue about in the first place, although we can do it for any sums.
Absolutely. And that's where lifetime trust planning can come into effect, is ultimately someone at an earlier stage in life, when they're looking at the assets that they have, placing assets within trust well in advance of a relationship or a marriage taking place. That trust being a separate legal entity, holding things away from their main estate, can offer some protection in the event of a divorce in future.
Yeah, absolutely. It's as we stated earlier on, if that person never actually owned those particular assets in the first place, they're not there. I mean, they're not there to be considered as part of that matrimonial pot for division. Don't get me wrong, other solicitors will try and challenge that, as I would expect them to, but it puts you on a very, very strong footing in the first instance that those assets were never there to be considered in the first place.
But all about timing. A hastily drawn up trust on the eve of a wedding when we're having cold feet potentially stands less of a chance of success than something done a decade before you even met your partner.
Absolutely, and we get exactly the same thing for prenuptial agreements. Folk come a week before they're due to get married and it's this blind panic, but it's just not the way to go about your financial legal business. It's just not. And
you must come across, because I know we do, situations where clients are already married and they come to us and they're worried about their elderly parents, potentially poor health, maybe passing away, and whether things can be done at that point to safeguard against kind of potentially losing the assets in a divorce. And I think it's important to stress that it's not too late to do something, but it does become quite nuanced. It's all about intention, it's all about the when, it's all about the why. And ultimately, if a parent wants to leave an inheritance in a structured way that is for your benefit but not to you, that's their prerogative at the end of the day. So I guess in terms of somebody asking those sorts of questions, the best advice we can give them is to take some proper estate planning and family law advice.
Well, that's it. And as soon as you know there are assets you're concerned about, or relationship situations you're concerned about, whether that's as the parent or as the potential partner that's entering into these things, if any of these things are stressing you out in any way, shape or form, then it takes away from, I suppose, these special moments of your marriage and things. So deal with these in advance. Don't wait until the week or the month before your wedding and put all this additional pressure on yourselves. Deal with it in advance and then actually enjoy your day when it comes.
Absolutely. And coming back to the prenuptial point, Are you finding that they are more becoming more accepted in terms of couples entering into them?
Yeah, I would say so. And certainly anytime people come to us regarding prenups, it usually is something they've had a conversation with their partner, with their spouse in advance of that. So we're not blindsiding anybody with this. It's sensible conversations that have taken place. And as I said, nobody's entering into a marriage for financial gain. So it's not something that's going to become acrimonious. And that's what we always have to stress at the outset. This is not an acrimonious process. Don't get me wrong, some points of family law are. This isn't one of them.
Yeah.
And in that scenario, we're looking to get things across the line as smoothly as we can for everybody and not to put anybody's nose out of joint. Because again, all we can serve to do there is take away from what's going to be these folks' biggest day of their life, their most special day of their life. And it's our job to make sure that that goes by without a hitch, that they don't have this overarching concern sitting there.
Particularly in relation to trust, we have to factor in the tax implications with that. We can do a very good job of fixing one problem, which is about safeguarding the estate for future generations or ourselves, but that in itself can create a tax liability that wouldn't otherwise exist. So really just to emphasise the point that this planning has to be factored in amongst your entire estate planning journey and making sure that it's right for you. We don't want to fix, as I say, one problem and inadvertently create another one. Now, people who listen to us regularly will know that I can't get through a whole episode without talking about inheritance tax. It's a love of mine. It's relevant though, because whether it's a discretionary will trust or a trust that you set up during your lifetime, as I mentioned, it does have an impact from an inheritance tax point of view. But careful trust planning can help avoid passing an inheritance tax liability down to your children. If you have a sizable estate and your children are wealthy in their own right, as well as protecting from divorce, you can avoid passing a tax liability down to them. Or if they're not so put together and they've maybe got some concerns or they're doing things that they shouldn't be doing, it's a way of kind of creating some control and flexibility. So ultimately it can be a sort of 3 birds, 1 stone type situation.
Well, that's it. It's control, it's flexibility, it's peace of mind as much as anything else. From our perspective, certainly a well-structured will and with trust provision in there gives that family that flexibility, whether it's during lifetime from the trust perspective or at the point of death if we're talking about wills with trust provisions. We see cases on a regular basis where post-death planning comes into play, a deed of variation, for example, and that can massively adjust what's left to these children, and more to the point, how it's left to them or how it's held. And certainly from a divorce perspective, that could potentially make things so much clearer. Yeah,
and I think that's what's kind of unique about us, but there's lots of firms out there who are very good at estate planning work and lots of firms who are very good at family law, but we're quite unique in the sense that we can bring those two parts together. And actually you are one of the kind of unique solicitors here who spent quite a lot of time in our private client department before moving down to family law, so you've seen both sides.
Absolutely, it gives me a very unique or more in-depth is maybe a better way of putting it, insight into the negative effects that not dealing with these things can create. So when I've got clients coming and speaking to me with these, whether it's problems already or potential problems, certainly being able to advise on both sides of that spectrum and signpost them in the right direction is absolutely invaluable.
Absolutely. And I think it's important for people to know that drawing up the right will or having a trust, that's the foundation. That isn't the whole be all and end all. It's important to keep these things under review. We recommend that our clients look at this type of planning every sort of 3 to 5 years as a bare minimum. The law changes. We saw that most recently with the Labour government came into effect and the changes that they've made to inheritance tax. So it's important to do these things, but keep it under review.
Absolutely, and especially when it comes to not just on a regular basis, but if there is a dramatic change in your life circumstances, whether that's to do with separation, whether that's to do with kids, divorce, whatever that looks like, then that's absolutely the time for another review. Even if it only happened a month ago, get in and speak to somebody and make sure everything's tied up, make sure all those points are covered.
Well, as we wrap up, Steve, in terms of your top tips for someone listening today who's worried about protecting inherited wealth, what does that look like?
If you're a parent or guardian in the first instance, then think about, first of all, whether a will trust is right for you and your family. If you're not sure, come and speak to us about it. We're more than happy, even if you're not 100% sure that is the right avenue for you, come and speak to us. We'll be able to signpost you if that's the case. But certainly from our perspective, from a divorce or family law perspective, leaving assets into a trust rather than outright can make a real difference in these types of scenarios. I suppose next, if you are about to get married and you've got significant assets, then strongly consider a prenuptial agreement. As I've said before, it's not something that should be viewed as a negative or a lack of trust. If the parties trust each other as much as any married couple should do entering into that journey, it's not going to be an issue. So it's not as difficult a subject to broach as you might expect, and the dividends it can pay back in the long run are absolutely immeasurable. If you're thinking about the timing of any planning, as you've said, don't wait. Don't wait until there's an issue. As soon as the issue arises, it becomes much more difficult, if not almost impossible, to retrospectively fix that. Deal with it in advance. So get in there, speak to somebody, and make sure your situation is already the suitable one for your own personal set of circumstances. And from a practical perspective, on divorce, if you have recently received inherited funds, you're going to strongly think about exactly what you do with those. As I said, the initial position for the law is that those inherited funds should be separate from the matrimonial pot. But as soon as you start doing anything with them, whether that's a new kitchen in the house, whether that's adding a conservatory, whether that's paying off your mortgage, at that point, all these things start to be up for grabs, for want of a better word, when it comes to the division of those assets. So if you're concerned about that, again, come and speak to us. We'd be more than happy to discuss those things with you. Taking specialist advice is absolute key. And consider it from all sides of the situation, not just from a family law perspective, but think about it from a financial planning perspective as well. Our job is to look at all these various avenues and make sure that you're steered the right way for your own set of circumstances. We can deal with that and we can take that stress off your shoulders. I quite often end up saying to clients when they come in for an initial consultation, if the only thing we achieve today is bringing your shoulders down a couple of inches from your ears, then it's money well spent. Because if you know that somebody else is there to take over that stress, that is invaluable. But yeah, as you've said, the last point to bring in there would be make sure you're reviewing these circumstances regularly. Your circumstances will change, and they might change without you even particularly realising it's happened, whether it's, for example, a pay rise, an inheritance, a lottery win, because that is a specific type of case we have dealt with at Jones White as well.
That's a whole other episode in its own.
That's an episode all to itself. But these are all genuine situations that we come across. So if there's anything that changes in your life, just stop for a minute and think, is it something I need to have reviewed? And if you're unsure, then the answer is probably yes. Just come and speak to us and we'll guide you as far as that's concerned.
Brilliant advice, Steve. Thanks so much. It's been really valuable having this conversation today, and I think a conversation that lots of the families that we deal with need to have. So thank you very much.
No, thank you very much for your time. It's been a pleasure.
If you're looking for advice on prenup, separation, just understanding your options, then come and speak to our family law team here at Jones White. And if it's wills, trust, estate planning you need, you know where to find us. We are a multi-service law firm covering estate and later life planning, litigation, conveyancing, immigration, and, as we know, family law. If there are any areas that you would like to hear covered in a future episode, please get in touch at info@joneswhite.co.uk. Thanks so much for joining us today. Tune in next time for more There Are Some Things Certain in Life.